Chairman Solomon come forward, and we'll welcome.
Welcome. Thank you. Thank you. House Bill 5454.
We're going to be switching gears a little bit. Go ahead if you want to introduce your bill.
Thank you, Mr. Chairman and members of the committee. House Bill 5454 by myself makes some critical new updates to the Access to Public Records Act. As you know, the technology has changed significantly over the years, and this is a law that just really hasn't been updated to the point in which it needs to. So I've been working very strongly with Senator Lou DePalma, who's worked very hard on this issue, and came up with this bill. And it would make several amendments, including requiring documents that are discussed at an open meeting for a public body to be posted or linked with the electronic filing of the agenda. For subpoenas, it would generally make public any subpoenas that are issued by a government entity to a public body or official regarding official business. It would reduce the charges that can be imposed for the copying or retrieving of public records. And for 911 calls, it would allow the release of 911 calls under certain circumstances. For police records, it would clarify the public's right to obtain arrest and incident reports, final investigations of police misconduct, and body camera footage of police use of force incidents. Additionally, it would increase the penalties for violations. It would also make elected official correspondence public to the extent they are connected to the official's formal duties. I know it makes some significant changes, and access it's not always an easy thing to get over, but it's something that we all need to do because the public has an interest in knowing how their money is spent, what we're doing with it, and I think it's a great law, and thank you.
Thank you. Any questions from the committee for Chairman Solomon? No questions. Great bill. Okay. Thank you very much.
5442 is an act relating to public records. Access to public records, it would provide that any reports of investigations conducted by internal affair units or their equivalent are public records. The names, addresses, and other personal identifiers could be redacted where disclosure would constitute an unwarranted invasion of privacy, but when internal affairs investigations are undertaken, it's usually because someone thinks that people haven't been behaving as they should, as they were supposed to, and the public has an interest in hearing about that. So I have introduced this legislation at the request of the ACLU and Common Cause, and perhaps they will have something to add. Thank you.
Okay, thank you. Any questions from the committee? Okay, then we'll go to Steve Elquist.
One sec. Hi, thank you, reps, for hearing me. Little story about access to public records. After the governor evicted unhoused people from state house property in December, Uprise came into possession of a document that indicated that Governor McKee was playing fast and loose with federally mandated HUD requirements regarding housing. Without going into too much detail, those camping on state house grounds or property found themselves at the front of the line for scarce housing, bypassing people who had waited their turn on the coordinated entry system. From talking to unhoused people and to people who work to alleviate homelessness, I figured there was more than one bit of behind-the-scenes stuff going on. The governor and a housing secretary, then Josh Saul, refused to answer questions from me and from other reporters in the state, including the Boston Globe and the Providence Journal. I used APRA to request emails about how those evicted from the state house encampment found housing. I was hit with a bill for $930. One difference between Uprise and the Boston Globe or the Providence Journal is that $930 is about twice what I make in a week. I can't afford a lawyer to do this work. I did a GoFundMe once for an APRA, which was many, many hundreds of dollars, also from the governor. But I really don't like the governor is taking money that way because I have to take it from my readers, I have to take it from me. It feels like when I have an issue that is in the public interest, and I really believe knowing where the money is coming from for this type of, or who's working, or what policies are being bent or broken, and when we're housing people, I think it's important that we know that. And I don't think I think there should be an exception. And in the bills that are coming to you about these, there are exceptions for the public interest to make it free. When the governor replied to my APRA, they told me that there were 740 documents that may be responsive to my request. They estimated 62 hours to redact them, and they're going to charge me $15 an hour for those $62 hours. What they're doing is they're taking information out of them. They're charging me to redact them, and I don't have any sure way of knowing other than to basically go to the Attorney General to say, hey, is this redaction proper or not? Are you protecting yourself politically, or are you truly protecting people? And I can't tell from looking at a redacted document what the difference is, of course. They also want to point out that that was only the beginning. What they sent me was an estimate. They said it might take more, but they wouldn't begin the process till I paid them $930. And then if it turned out, oh, well, it's going to take a few more hours, I'd have to come back with a couple $100 more maybe to finish the job. So they wouldn't even give me a solid number. They said, this is the estimate, and it might be a lot more. I believe that this request was squarely in the public's interest. And I also want to point out that this week, while working on a story of the underpass eviction in Pawtucket, I was met with the same wall of secrecy from the state. The 5 people evicted were put into a hotel. I was told that money was provided by an anonymous private donor. No idea who that is. And that the money that's going to be used is also put them into an apartment. They're working on getting an apartment for the people. So some anonymous donor gave the governor or this Department of Housing about $25,000 to $30,000. Don't know who that is. So that the people who are housed there, and believe me, I want these people to be housed. I'm very, very adamant, and I'm happy that they're finding housing. But we need to know, I think, how this happens, right? Who's giving the money? Where is this money coming from? What favors are being called in, or what favors are being pushed off? We know that there's something weird here. So excellent, they found housing. Bad that we have no idea what's going on, and that the governor's playing fast and loose. So what I need is a powerful APRA to do this work. I need the exception for documents that are in the public's interest. I am also going to say I'm not a serial APRA user. I mean, we hear sometimes about people who just put in request after request after request to annoy people. I put in maybe 3 or 4 a year, and they're always for what I consider to be important things. I am not somebody who abuses it. I also want to say that the Attorney General doesn't have the manpower to deal with the complaints. They don't have the people there who can do this. I think they have 1.5 people, like 1 part-timer and 1 full-timer working in a 4-person unit, but many people, one was out on military leave, another might have been on a pregnancy leave or a child care leave. So they don't have the people doing the work. So if you bring a complaint, it can take weeks. Think about this, the encampment in the State House was cleared in December. I still don't have any clarity from the governor, and they will never answer me unless we get the power to force them to answer, or a new administration comes in and turns over old documents, which could happen. I'm not going to get these, and we're not going to know. Maybe the Boston Globe can spend $930 to investigate this, and that's fine, but think about what that does to smaller reporters and people who are really working hard to do this, and if it's only a matter of you have the money to make it happen, I don't know if that's what we want for democracy. So that's my testimony, and I'm happy to take any questions.
Any questions from the committee? No, thank you.
Thank you.
All right, Mr. Brown, you go.
Thank you
Go
very
ahead.
much. Stephen Brown from the ACLU of Rhode Island, here to express our organization's strong support for this legislation. We want to thank Representative Agello for introducing it. It's important to understand the background of this bill. The Rhode Island Supreme Court issued 2 major Access to Public Record Act cases, one in the 1980s, one in the 1990s, and both of them held that the public is entitled to obtain final reports of investigations of police misconduct. They also held that those reports can be released in redacted form, so identifying information is not provided, but the public had a right to see the end results of internal police investigation reports. Unfortunately, many years later, in 2017, the Attorney General's office issued an opinion in which it made a distinction between investigations that were prompted by citizen-generated complaints and those that were prompted internally by the police department itself. And we felt they made a completely arbitrary distinction and said the latter, internal investigations initiated by the police, were not necessarily subject to this public release as citizen-generated complaints were. As a result, there have been a number of incidents where individuals have filed requests for these records, and they've been denied them on the grounds that because these particular investigations were initiated by the police department, they don't have to be released. What this bill would do is put both types of investigations on the same level and allow the public to continue to obtain access to them. We've heard objections, and I assume you'll hear from Mr. Wardell that, some of these investigations are really on trivial matters, minor personnel matters. Whatever they are, the public should be able to see how police departments are investigating allegations of misconduct. We don't think it should be for the police department to determine whether it's trivial. There should be a right of the public to be able to monitor, have this oversight, and see if these internal investigations really are providing the discipline that might be deserved. So with that, I'll be glad to answer any questions, but as I said, I hope the committee will support the bill.
Yes, Representative Hall?
Steve, can you back up just a second?
Sure.
You said the Supreme Court they made decisions, and the Attorney General's office came in and made their own decision?
Right, so what happened was, yes, so the Supreme Court issued these decisions, and then the Attorney General's office, in this advisory opinion that it issued after a police department refused to turn some of these documents over, and they alleged this distinction that I mentioned, that the two Supreme Court cases happened to involve citizen-generated complaints. The entities that asked for them asked for citizen-generated complaints. So the Attorney General's office then said, see, those two opinions only talk about citizen-generated complaints. They didn't address police-initiated complaints, and we believe that those are different. They're not subject to those Rhode Island Supreme Court opinions, and we're holding that they do not necessarily have to be released the way others do.
Why didn't we go back to court?
We did, actually. We went back to court. We weren't involved in the Attorney General advisory opinion. That was somebody who brought the complaint as a private citizen, and the Attorney General's office then issued this opinion. Later on, an individual who filed a similar complaint did come to us. We filed a lawsuit in Superior Court. This was a few years ago, and the case ended up getting resolved. The records were turned over, ultimately. So the issue remains, the Attorney General's opinion remains on the books, and the Supreme Court has not had an opportunity yet to address this distinction that was made in that advisory opinion.
But you said it was resolved. So
Yes.
we went to court and it was resolved.
It was resolved informally. It wasn't resolved because the court issued a decision saying this distinction is, the Supreme Court saying, we agree with this distinction or we don't agree with this distinction. It was resolved by, the police department ended up agreeing to release.
The courts were right.
No, they never acknowledged that. They agreed, they determined that the records could be released without infringing on privacy, and so they were willing to turn it over as opposed to continuing to litigate the case in court.
Okay. Thank you, sir.
Yeah.
Any other questions? Thank you. Mr. Waddell?
Thank you, Madam Chair. Did I miss the calling on 5454 as well, which also deals with the APRA request, or are you doing that separate, or?
Yeah. Yes.
Yes, I missed it, or may I?
Yeah, you can
tell-
address that as well.
We are, as far as, so let me introduce myself for those of you that don't know me. My name is Sid Wardell. I am the Executive Director of the Rhode Island Police Chiefs Association. 34 years law enforcement, 27 years in the community of Little Compton, 10 years as the chief of police, and now 8 years as the executive director. Or 7 years, if my math is off. Time flies. So I appreciate the opportunity to testify on these bills here tonight. First and foremost, as written, we are opposed to the bills as written. And I'll start with where Mr. Brown left us in the idea of internal investigations. And there's some distinction that I think is relevant, that with law enforcement, there are complaints that happen involving what we've heard as misconduct, but there's also discipline that happens internally within an agency that are violations of policy. Some may say that as there's no difference between the two. I would beg to differ the difference. Violation of policy, which could be instances of an officer not wearing their hat, it could be calling in sick, it could be missing a shift, it could be involved in a motor vehicle crash with their vehicle. These are all things that if an officer is found to have violated policy, there would be an internal investigation on that and a possibility of discipline being handed out. I would suggest to you that discipline in those types of cases are not meant to embarrass a police officer or any public employee, which police officers are. Discipline is meant to be implemented to correct behavior of an individual, which you believe is still an asset to the department, but needs some corrective action to make sure that what they did or were doing doesn't happen again. I would suggest to you that if this bill goes into place, we're going to allow and we're going to say only police officers, mind you, that anything and everything that happens in their personnel jacket, which may be a violation and ends up in discipline, now becomes social media eligible. Nowhere else do we do that, nor do I suggest that we should. Particularly in a time where law enforcement, we can't get officers as it is now because of the scrutiny that is placed on them. We can't get officers because it's not the job of the day after 9/11 that everybody wants to be a part of. We are actively out there trying to get officers. And if you've never had an employee or yourself where you made a mistake or screwed up, if you believe that that should be out there in the public to be scrutinized, then you're of a different mind than we are administratively with the police department. So I think there is a line. I think there's an area that we can come to, and we do know criminal records, or criminal charging, internal investigations that come that way. Those are the types of reports that eventually are going to end up being out in the public. I would suggest that there's an appropriate time for that, just like another portion of the proposed legislation, which speaks to initial narrative report, and now the legislation speaks to having every single piece of the investigative report, whether it's internal or external, that would have to be released. I would remind you that in cases where there are criminal charges to be brought, there is the right of the accused to not have certain information that is released. And there's an appropriate time for that to be released. And I would suggest that a time that when an officer is in fact found guilty of charges of some type of behavior that is criminal, that's the appropriate time for that to be released, not in an instance where we're talking about body cameras coming in, a time period of those having to be released. Those types of things put out into the public perception, and people view them in one light or another, but certainly does not give the opportunity for a department to fully investigate a case. So my argument to you is that specifically when officers are cleared of wrongdoing, not of criminal misconduct, that those types of things are not appropriate to be released as an open record. Next, if I may, subpoena power. I know there's in the bill that speaks to subpoenas. If anybody understands the process of why subpoenas are used, I believe it says unless the court orders otherwise. Subpoenas are used as a process for law enforcement to gain access. Usually that subpoena happens by going before a grand jury. That grand jury independently looks, gives authority to law enforcement to then issue a subpoena for certain records. Those are criminal cases. They're not anything else. Again, to say that those types of things have to be released, and I think I know maybe where it was pointed to on a previous instance, not necessarily to do on the law enforcement side, but this has an implication on law enforcement. By the mere fact of releasing all subpoenas is going to impact criminal cases as they proceed. Lastly, if I may, and we heard testimony from the press in asking for information. I know it was not directed at the police department in this particular case, but I want to let you know what is happening today in law enforcement. Body-worn cameras are being implemented and rolled out. We are actively receiving requests for more and more data around the body-worn cameras along with police reports. As the current law stands, we can do a redaction. There's the allowance of, I think, of an hour for the first part to be free to search, and then $15 per hour to do that redaction. I believe one of the bills actually says that redaction would not be included in that. It takes about an hour and a half of time to do review and redaction of 1 hour on video. So you can see just the buildup as a compound and the portion of the work that needs to be done on reports, on video for that redaction in some instances is actually, and it should not be punitive, and we should find a way to correct this, but in many cases, it's stopping somebody from just coming in because they want to get a video of what happened at their neighbor's house. They saw the police car there. They want to know what happened on this report. Or they come in and they ask for Officer Jones for the last 10 videos with no purpose other than a motive of their own. So certainly if there's an investigation, if there's reporting that's being done by a newspaper, I think there's some type of line there that we need to find a compromise, but a general structuring of the statute to say that there will be no further charging, that the fee is going to go down, it's going to bury law enforcement. We probably, other than maybe the governor's office, we would probably receive collectively across the state the most requests for those public records, and it's just not something that can be done. And the ability to keep that in check, unfortunately, is by the fact of if somebody wants that information, to be able to charge them for it. Madam Chair, that concludes my testimony.
Any questions from the committee? Representative Jello?
I think the public is concerned that, that we have carved out law enforcement officers, people who are empowered to carry a gun and pepper spray, make arrests, take people off the streets, out of their homes. We've empowered those people and are not able to know when there is question about an officer or a group of officers' behavior. I think back to the Officer Joseph Handley case in Providence of brutal treatment of someone in an arrest attempt. The person ultimately was let go. There was video at that time, I believe it was bystander video, but I know that the public, people of Providence and people around the state really were interested in knowing what happened with that investigation and investigations like that. I'll say it again, police officers have tremendous power over us all with guns and handcuffs and pepper spray, the ability to take us off the street, even if we're not ultimately charged. It's tremendous power. Teachers don't have that power. No other public employees have that power. And yet we're asked, I think we're asked, trust us. We'll let you know, we'll handle this appropriately. And I think the public wants to know more. The public wants to be able to hear, was there an internal investigation, and what was the result of it?
May I respond? Rep, of all the times that you've heard me come before you or ever testify, I think you've always heard me profess that law enforcement needs to be transparent, and I agree with that. And I truly mean that, and I say that here before you. But we can't always feed the desire of immediately knowing what's going on when we have to respect that there are some processes that have to go into place. The case that you speak of, the first videos and those videos that came out in many other cases. At first, our video that starts with the public. That, by the fact that it's the public has knowledge about it, I agree with you. I agree that there is opportunity there at some point that there should be the ultimate on identifying and talking about what is the result of those investigations. And I think I said that in my testimony. Those are cases that we're talking about that are investigations to determine, was there criminal behavior by the officer? Is there violation of department policies? And ultimately, when a case goes down the road of criminal charges like that, just like any other defendant, there's limitation on what can be released of that info. So, as you know, we're working on Leobor, we're working on other areas of trying to satisfy the right to know of the community, but also recognizing that there is a process for that to happen. So, and I you know, there is a portion of trust us, right? And that trust is earned through transparency. Fully understand that. So that's why I said I think there's areas of this that we could get to, but I made a point of some instances when I don't think behavior or corrective discipline, as with anybody else, really needs to be out in the public eye. And as this bills, as they are written now, all of those things would come into play. So that's where I would love to work with, you know, yourself and Rep. Solomon on coming to some conclusion on where we can get to on those. As you heard testimony as well, that the courts have distinguished on what some area of release, and then we have the Attorney General's office on a need to know, a right to know basis, public interest on what happens. And certainly there is a distinguish between cases that originate in the public and cases that originate administratively within a department.
I just have one more comment, and that is that the Attorney General's, I sometimes wonder whether the Attorney General's office is the appropriate office for making these decisions regarding access to public records, particularly as it regards law enforcement, because so much of that office, the Attorney General's office, is involved in partnership with law enforcement. And so perhaps there ought to be another office charged with looking at access to public records, at least as regards law enforcement. Something to think about.
Yes, ma'am.
Any other questions from the committee? Representative Hall?
Sid, you know me very well. I was a commanding officer of the Records Bureau for some time. And I always took the attitude, the records are not my records, they're the public's records. And I've always operated, when I was in charge of the Records Bureau, that they belong to everybody here, not to the police department. I've worked under 2 chiefs during that time while I was in the Records Department and was able to build a rapport with access to my records, which are not my records, they're your records. When you stop and don't easily give access to the public, I understand what Representative Agello is saying, and a lot of people around us saying, they don't believe us, and we gotta give something back. I've never had any difficulty in my capacity as commanding officer of the Records Bureau, but I understand. There's nobody no more public than we are. There's nothing more embarrassing to see my pay in the paper every year. But I know that I'm public. You have access to it. If you have access to what I make every year, and I can live with it, may not like it, but it is part of what goes on at being public and as a police officer. I have some difficulty sometimes with the police sometimes as they look as protectors instead of preserving what actually needs to be preserved. And in the records department, we know what we can release and what we can't release, according to the Attorney General's office, because they give us a list of parameters on what can be released and what can't be released. I found it sometimes very disturbing when we don't give information that we can give, and it really hurts our profession. That's the problem we're having now, and I understand a lot of people who are listening to this, oh, well, we don't want to do this, you got to trust us. Trust works both ways. Works both ways, and if you're able to trust me, I'm able to trust you. And I had that rapport when I was in charge of the Records Bureau and the police department, and I can still have that rapport. We just need to get there so that everybody else feels comfortable when they talk to police, and especially access to public records, because there are parameters, and you know it, and I know it. It's just meeting the other parties halfway. I needed to say that because as a police officer, sometimes we get a bad rap. But I'm telling you, sometimes we bring it upon ourselves. So thank you, Mr. Chairman, and thank you, Sid. And I don't mean to single you out, but I needed to because you're in the same profession. Thank you.
Thank you. Any other questions? Representative Tanzi?
Thank you. This one's for Steve. I heard Representative Hull talk about working under different administrations and how things have changed to some degree. I'm wondering, I don't know how many decades you've been in this pursuit, but I'm guessing you've seen a lot of changes over your time. Would you say that, over time, the things that have been redacted have increased? Have they waxed and waned over the years? And how difficult it's been for you to get different, no matter who's in the governor's office, the attorney general's office, the chiefs of police throughout the state. Is it an art or a science, I guess?
Yeah, it's not a science. It is waxing and waning. You have to keep in mind, we're talking about literally hundreds of different agencies, and each agency may operate in its own manner. The people who are in charge of an agency change over time. So I really can't, I can't say there's some linear response to that. The other thing is that other things change as well. Technology has changed. So the types of records one can get or one can ask for are much different than they were 10 or 20 years ago. So there are additional challenges that come in where agencies didn't have to think about whether they had to release records, that now they do because they're in an electronic format and it's easy for them to provide information. So I can't give you a definitive answer. I was going to say, I can tell you we've always been busy handling open records complaints.
Yeah, I guess my conclusion and you've helped me formulate that with your response, is that times have changed, and this deserves a comprehensive look, and I smell a study commission. Thank you.
Are there any other questions from the committee? No? Thank you.
May I didn't realize that you were here. I came up to testify on Representative Jello's bill. You've now heard testimony from a couple of people about Representative Solomon's, and I have a few, if it's okay, I have a few comments. I know there are some other people in the audience who also are here to testify on Representative Solomon's bill. Sorry. 5454, Representative Solomon's bill. It's a comprehensive open records reform bill. It has been over a decade since the General Assembly has revisited the open records law in any sort of comprehensive fashion, as this bill tries to do. As we heard in the colloquy before, a lot has changed in these years in terms of access to records. You'll hear from other speakers who will talk about a few particular provisions in the bill. I just want to very quickly address a couple of the provisions that do deal with police records, which Chief Wardell briefly touched upon. There are a few aspects of the bill that address that particular topic. I just want to mention two. One has to do with access to narratives of arrest reports. For many years, the open records law has been read to require access to initial arrest reports, including the narrative, the police officer narrative of the arrest, what prompted the arrest and the arrest itself. Over the years, what we have found, what members of the news media have found, is that some police departments sometimes do not provide that full narrative. They just provide sort of like a cookie cutter, one paragraph summary of what happened. What this bill would do is clarify what we think the open records law was always intended to do, which is require the narrative report of the arrest itself, not in the future the investigation that gets conducted afterwards, but the actual narrative of the arrest. And the bill is designed to ensure that that information is provided. It's really key information that the public deserves to know. One other provision I think it's worth mentioning, because again, this is something that Chief Wardell mentioned, has to do with body-worn camera footage. Again, new technology, this is something that the open records law ought to address. A few months ago, the Attorney General issued regulations governing body camera worn footage, how it can be maintained, when it can be released. And this bill addresses one particular aspect in which we disagree with what the Attorney General's regulations do. The Attorney General's regulations generally set a 30-day time limit for the release of body camera footage. There's an exemption in the regulations for matters that are still under investigation. What this bill says is that if it is a use of force incident, types of incidents that the public really is interested, concerned about, and we feel has a right to know, the 30-day limit is the limit. There shouldn't be an open-ended exception to wait for an investigation to conclude. The public should be able to see that body camera footage within 30 days. So those are just two examples of what's in the bill. There are many others. You'll hear from other witnesses about some of the other provisions, but we do think the time has come for a comprehensive reexamination of the law, and we hope this will be the year. Thank you.
Any questions from the committee?
I have one.
Oh, go ahead.
If there's an investigation still onward, and it's still under investigation, and you know that, or we know that it could be harmful to the public, that's okay?
Well, I'm not sure what you mean by harmful
No, I'm not saying that we won't release it. But if all the facts aren't in yet, and we've catch just a piece of it, and we're trying to get the piece of it, but you're gonna say 30 days, just release everything?
Release the body camera footage. Again, it's never in and of itself necessarily the whole story. But that will be true after the investigation is completed well. Other individuals might have different viewpoints about the thoroughness of the investigation. but the public, after 30 days, which is it's a fairly reasonable, amount of time, the public should not be kept in the dark if it's this type, we're talking about use of force incidents, so we're not talking about the general interactions. We're talking about an incident that probably is public already. There may often be bystander video footage, that can be out there day one.
I understand.
So, okay.
I understand. Thanks.
Thank you.
Yeah.
Any other questions from the committee? Mr. Marion, you have the floor.
Great, thank you. So I'm testifying on H5454. As Steve said, this is a comprehensive overhaul of APRA, first time in over a decade. And it's really, broken down into three large set of changes. One is dealing with emerging technologies like body cameras, other instances correcting incorrect precedents, in our view, as Steve talked about. And then also, there's codifying some changes that have occurred without statute, such as the Attorney General has created a website with all the APRA and OMA decisions, but putting those into law, which we think is a good idea. I'm not going to speak to all of those. Steve talked to some of the police issues. I'm going to talk a little bit about the costs and penalties sections, just to highlight those. So this would reduce the cost to the public for per page costs for receiving a copy of a record. Right now it's 15 cents. It would reduce that to 5 cents, which we think is closer to the actual cost to the public agency for producing that. The second is, the chief mentioned, increasing from 1 hour to 2 hours, the free search portion for the person requesting the records. Oftentimes, the search takes a while, and we think for increasing that from 1 to 2 hours is reasonable. And also, as he said, eliminating the charge for redacting documents, but also for people get charged, believe it or not, for producing the denial. So people get letters, reporters get letters saying, we're not going to give you these records, but here's a bill that for what it costs us to produce the letter denying you the record. We don't think that should be that way. The thing Steve Alquist talked about, right now you can go to a court and request a public interest waiver for the fees. But this would also allow you to go to the public agency or the Attorney General and ask for that as well. And we think it should start with the people who are actually in possession of the records, who can waive that. And it also allows for you to appeal that. I want to point out, in the news today, there's a great example. A reporter asked for the resume of the new medical director of Buddha and was denied under APRA. They wanted the resume of somebody who applied for and got $174,000 a year. Sorry for pointing out the salary. State job, right? Something they could just go to LinkedIn and probably get, and they were denied under APRA. So I think clearly there are problems with abuses of our public records law. So the last thing is trying to deal with those problems, which is increasing the penalties. So there are two different levels of penalties for the two levels of violations, and this would allow the courts to impose higher fines to put more teeth in the statute. So we think overall, this is a very good comprehensive set of changes to really the law that is the pillar of open government and transparency in the state of Rhode Island. So I'm happy to take questions.
Any questions from the committee? Thank you.
Thank you.
And there's two other people on this bill, Steve Alquist and Scott Pickering.
I'll be very brief because I already spoke on similar legislation. I do want to point out that I think it was a little ironic of something I heard Chief Wardell say earlier. Body cameras were introduced to be a tool to help the public hold the police accountable. But now I'm hearing that it's accessing that video might be too expensive to be generally available. So that's a little bit ironic, right? That it's a tool to basically say, hey, police, need to be more accountable, but if you want to access that, you better cough up a whole bunch of money to do it, because he wants to charge more than $15 an hour to give you an hour of video. It might be better to think of it as, we're going to release the video all the time for free to everyone, to just sit on YouTube or sit on somewhere, instead of thinking of it the other way around. I think that was really weird. I also want to point out that in the case of the Sergeant Hanley video, which came up earlier, there were two videos. One was the body cam, and it was pretty useless because it was so close to what he was doing to the person on the ground that you couldn't really make out what was happening. It was privately owned video from a top, from outside an apartment that videoed the stuff where you could really see what was going on. But the police took that video from that private individual and then said it won't be released. It wasn't the police confiscated that video from that person and then would refuse to release it. That was owned by whoever took that video. I don't know what their feelings were about releasing it or not, but the police then said, oh, this is a public document now. We've confiscated this, it's ours, and you can't get it. And then they held on to it for something like, 3 years? Or 2 years, something like that, until Rep. Batista released it, maybe lost his job. One final thing, I agree with Rep. Paul that these are the people's records, and that's one of the reasons that we should be having this conversation in a very robust fashion. And I also agree with Rep. Agello, or at least something that you suggested, was that the AG might not be the best person to be doing this job. If we thought of it more as like a library, and a librarian had maybe a librarian with a little bit less public interest, but a librarian who could balance those interests better, because the AG is really the state's top cop, right? And no matter how you slice it, I can't imagine that he won't be somewhat biased towards the police side of the issue in every case. And I know that if I were in that position, I would probably be biased. And so I don't know that it's wrong for him to be biased, but it might not be the best person to be in that position. So I think we really should consider, like I said, Secretary of State might be able, if with a little more funding to handle it, might be a better, smarter place to put that kind of information, a centralized location for all this data that he can then ascertain as to whether it goes out. And that's my testimony. I'm sorry to come back for a second bite. Thank you.
Are there any questions from the committee? Thank you.
Thank you.
And now, Scott?
Yes, thank you. Scott Pickering. I am the general manager of the East Bay Media Group. We publish 7 newspapers from East Providence down to Little Compton. And I'm a member of the Access Rhode Island Board with Steve and John. And I'm not as knowledgeable or eloquent as the two of them on this topic, but I'll tell you my impression of the changes to the APRA bill. In my opinion, much of what's in there, and it is a pretty comprehensive remake of or update to APRA, much of what's in there is what I think you and I would commonly consider to be the public records of the state of Rhode Island. And there's instances where what we thought was comprehensive language has been tested, and the outcome was something that you wouldn't have necessarily expected, but the way the bill is written, the way the law is written, and could be interpreted, it might lead to a surprising outcome. I'll give you one example that I was personally involved in. One of the towns that we cover, my hometown, actually had a school department that was in a lengthy legal case, which it kept losing and appealing, losing and appealing, losing and appealing. And at one point, we decided to pursue, what is this costing? What is this costing the taxpayers? What is this costing the school district? They refused to release any information about what the legal bills were for this case. Nothing to do with the case itself. We just wanted to know what was the cost of this case. We appealed it to the Attorney General's office, and the Attorney General determined that the bills for this case were subject to attorney-client privilege and that if the district didn't want to release it, they didn't have to. So we never got any information about it, and that is a little area where the language is being clarified in this bill before you. Another big one I see all the time is this bill includes a requirement that public bodies meeting in public session have before them and have provided ahead of time the actual documents that they'll be discussing. So examples would be report from a consultant, a spending proposal, some sort of analysis or a committee report that they all have in front of them and they're discussing, they're holding debate on and maybe voting on. I can't tell you the number of times I've watched that play out at town councils and school committees where there's a live audience sitting there that doesn't have the information, can't follow the discussion, and a vote is taken, they can't reasonably contribute to the conversation, they can't offer public input because they don't know what is being discussed. So the requirement that documents being discussed in the public session of a public meeting be available at the public meeting, in my opinion, would be a great step forward. And again, common sense. I think the vast majority of the updates to this law are what reasonable residents of Rhode Island would consider to be common sense, and I hope you support it.
Thank you. Are there any questions of the committee? No? Okay, thank you.
Sorry. I did want to speak in support of the public access. I think that public access is a right to everybody, and it's the Supreme Court of Rhode Island has already dictated that we should have access. We should uphold what it already says. And there was something that Mr. Wardell had said that kind of struck me as odd, talking about how in a criminal investigation, the police departments don't release that information, but that's false because 2 years ago, I was part of a committee, community organization movement that had to call the police department. There was a couple of kids doing some stupid stuff on the highway and they got arrested. And the police took that information and put it on public and social media with their families' addresses and phone numbers. And those families were getting harassing calls and they weren't even proven guilty yet. So with that aspect, it blurs a line of saying that they don't release that information. So all public record should be accessible by the public, period. We have to have a transparent state. I do believe trust goes both ways. If you want a friend, you have to be a friend. So I don't, I get into debates with community members because I don't believe in abolition of the police, because I think they are a purpose. Everybody has a purpose. But I think that their overextending of power and abuse calls for a public record to be necessary. And I think that that has to be upheld. It has to be upheld that people should have the right to request public access, and it should be given to them. Under no means should it be restricted. And for people to have to pay for the access does not mean it's public access. What if there's people that it could harm and they don't have the money to do that? So it should not be a financial burden to a person to request public records.
Okay,
Thank you.
thank you.